he took money out of your account.
We've split money back and forth. I wasn't keeping tally.
I'm asking you what you...
I sent her money, she sent me...
Just a second. Now it's going to get difficult.
This is Judy Justice. Jill Wyatt is suing her ex-boyfriend, John Moore, for the money he spent while she was in jail.
Court come to order. All rise.
Have a seat, please.
Case 3046, Wyatt versus Moore.
Thank you.
Welcome.
Miss Wyatt, how long were you and Mr. Moore in a relationship?
We've known each other for about 18 years.
Did you ever live together?
On a couple of occasions.
When was the last time you lived together?
January, I believe, 2022.
Were you living in a house or an apartment?
It was a house.
Was it a lease?
Yes.
Was the lease in your name, Mr. Moore's, or both?
No. Apparently, it was an arrangement that he had with the person that he gave the money to. There was no paper.
We're getting far off the field, but it's getting more interesting. Now, Mr. Moore, Miss Wyatt, although I believe she probably has a good memory of this, I have just a sense that she's reluctant to get... In January of 2022, sir, you and the plaintiff were living in a house together.
No.
When were you living in a house together?
We've never had a relationship. We've never lived together. When you say live together, I come over, I got a girlfriend I've been having for the whole time, so I've never lived with her.
Do you remember the house she's talking about,
yes,
sir?
Yes, I do.
All right.
The one she destroyed.
I don't want you, just a second. I don't want you to play around with me.
Okay, I'm not.
Okay. Do you know the house she was talking about when the two of you were together some of the time in a house in January of 2022? That's a yes or a no?
Still a no.
Okay. So the house that she's talking about, you lived in alone?
I lived in with my girlfriend, actually.
Oh, just a second. Did Miss Wyatt ever come to stay in that house with you before you had your then current girlfriend?
When I first got the apartment, Miss Wyatt was gonna come. She didn't get along with the lady upstairs. She said she wouldn't come, destroyed the house and left.
Okay, well, if she destroyed the house, then she was in the house. Just a second.
Yes, ma'am.
If she destroyed the house, then she was in the house. And if she didn't get along with the lady upstairs, she wouldn't know that unless she actually lived there, because she's not telepathic.
Okay.
So she was, in fact, there.
I'm listening.
The thing is not difficult. She did, in fact, stay there with you for a while after you got this house.
Okay.
Not okay.
No, I'm seeing where you're trying to go with that. I'm trying to see what you're establishing. Yes, she did stay there. I'm agreeing with you. That was me saying yes, ma'am.
No. Taking a long time, but we're there. Okay. And then at some point, Miss Wyatt, you left there and you went into your own apartment?
Yes.
Okay, and where is your apartment?
I moved into a trailer.
That you were renting?
Yes.
I just want to know. I'm getting ahead of myself, but that's the trailer that he was supposed to pay rent on and utilities on when you went to jail?
Yes, ma'am.
So from 2020 until the time you went to jail for, what, 18 months?
78 weeks. Or, I'm sorry, 78 days.
What did you go to jail for?
In 2018, I received a, I'm sorry.
Just a second. 2018, you had a conviction.
Yes, I ended up serving the time in 2022 for...
For theft?
Correct. I stole Thanksgiving dinner, ma'am.
Are you sure? It sounds like 78 days is a lot. Were you on probation first?
Yes.
Did you take a plea in that case?
Yes.
Okay.
Correct.
What was the crime that you pled guilty to? I want to understand this. What, was it petty theft? Was it grand larceny? What was it?
No, it was retail fraud / shoplifting for $170.
Okay.
That's what it's.
And you were placed on probation.
Yes.
Why was your probation violated? Because that clearly was why you went to jail for 78 days, not because of an old crime, but because you violated probation.
I wasn't keeping in contact with my probation officer like I was supposed to.
Okay. So this case is about the fact that you asked Mr. Moore, who you knew for a long time, to take care of your expenses, your bills, while you were incarcerated, and you gave him your phone.
Yes.
Your phone had the wherewithal, and you he understood that because he acknowledges he used it to take money out of your bank account and pay bills,
Correct.
et cetera, with it. And you acknowledge that she gave you her phone for that purpose.
She gave me her phone not to pay bills, but to give her commissary and to keep up with her stuff.
Pay her bills, some to put in her commissary, and the last thing you said was pay her bills and...
Put money in her commissary and keep up with some stuff.
That's the keeping
Thank
up
you.
with some stuff is what we're talking about here,
Yep.
sir. Keeping up with what stuff?
Phone bill, I mean,
Just a second.
go ahead.
No, you are, sir. Keeping up with other stuff. Phone bill.
She bought a...
Jump.
I'm sorry, I'll wait till you
What
ask the
else?
question.
Phone bill?
She ended up buying a computer at that time.
No, I'm asking you.
So, no, I'm telling you, that came off the monies that was there. She was incarcerated. So, as a lot of things just come off the phone as a bill, like...
No, I'm asking you what you...
What did I?
What you were supposed to take care of.
It was never etched out. And what I'm saying is she wanted me to stay at her house while she was gone. And that was a means for her to keep in touch with me or keep in contact
Okay, no.
with me.
That's something that I didn't get out of this. So she wanted you to stay in her trailer, because she was living in a trailer at the time while she was incarcerated.
Yep.
Where had you been living?
At my house. That's where I currently live now, with my girlfriend.
With your girlfriend. She wanted you to stay in her trailer
Yeah.
with your girlfriend?
No, she wanted me to be there so she can keep up with me. That was a means of me having her phone and being in her car and being other thing would be a way for her to keep up with me while she was incarcerated.
And did you like that idea, Mr. Moore?
not
Just
really.
a second.
No.
I mean, did your girlfriend like that idea?
Not at all.
So why didn't you say to her, I don't want your phone and I don't want any responsibility? Shh, listen to me. I'm living with my girlfriend. We're not an item anymore. And I don't want that. Knew that I was staying sometimes in your trailer and not being home. That wouldn't be a good thing. So I'm not going to take your phone. Find somebody. Who are you?
Andrew Porter, I'm her son.
You're her son. Is there anything wrong with you?
No.
Do you talk to your mother?
Yeah.
Yes. Do you work?
Yes.
Yeah. So your mother could have given you her phone and said, pay the bills.
Yes, yeah.
Yeah, right?
Yes.
You can stand next to your mother. It's getting more fascinating by the moment. I want to tell you something. You wouldn't know the truth if it came up and
Why would
slapped
you
you in the
say
face,
that, Judge Judy?
Mr.
That's
Moore.
what happened.
You wouldn't know the truth if it came up and slapped you in the face and introduced itself to you.
Okay.
Jill Wyatt claims her ex-boyfriend, John Moore, misused money she gave him while she was in jail. John is countersuing for a false arrest.
So, do you understand, Miss Wyatt? I know that you thought it was going to be easier when you came here. It's
No, I did not. But
I'm very glad, because I have a feeling I could scratch the surface and I'd find more dirt. The more I scratched.
You would.
The more I scratched. Well, I have no intention of spending my life on this nonsense, because now I see that you have a child to whom you could have assigned the task of paying your bills, and I assume that you trusted him more than you trusted this guy, who seems to have a girlfriend, but then, it could be convenient. He can go here.
It's never painted that way when it's in the midst of things, but he...
Yeah, I also work out of state.
What?
I work out of state. I'm like a field engineer, so I'm only in Michigan maybe a couple weeks at a time.
That's okay.
I mean,
Paying your bills doesn't mean that you have to be in Michigan. You can pay your bills, and you could have done all of those things, except, anyway, this is your case. You allege that Mr. Moore took money out of your account, a couple of $1,000s.
$781 of that he gave to me while I was in jail, but the remainder he can't account for anything that he did.
So somebody did put in your commissary.
Yes.
Okay, he said he also sent you, there was $600 in the account when he gave the phone back to you. Was there $600 in the account when you were released from
Does he have
jail?
the date of that?
What's the date of it, sir?
She asked the question, but the answer did I give it to her? I don't have it. I didn't know I was going to come to court, so I didn't. But if I look at my phone, I'm quite sure, because all our transactions were via Cash App.
What do you mean you didn't know you were coming to court?
Never did I think we would be sued, so I wasn't keeping tally.
Well, but now you know you're coming to court, so it would seem to me if there's an allegation in your answer that I returned the phone to her, there was still $600 in the account, at least I would have that document.
Give me a second, I can get right
I
to
can
it.
give you a second. Although
I believe that amount was for the August rent on it.
Just a second. All I'm asking you is, did he put $600 when he gave you the phone? Was there still $600 in the account?
No, that was like a month after. That was for August.
What do you mean it was for August? What does that mean?
For the August rent. This whole thing with not living with me and not being with me or whatever is untrue. When I got out of jail, we were supposed to be working together, living together. This was no anything like he's describing with having somebody else or anything like that.
I would like to see, Mr. Moore, when you gave her back the phone, that there was $600 on the phone.
It's her phone. I'm not
Just
sure.
a second.
I'm saying I don't have evidence of her phone.
Okay, now.
But I gave, if you asked her, she'll tell you I gave her $600.
You say that the money that you used, and you acknowledge that you used some of the money, was because you drove her car for a half a block.
Nope, it was more than a half a block.
Well, just a second, let me see.
It says that.
Just a second. A job. So it wasn't a half a block. Just a second. I drove her car 1 block. I apologize, it wasn't half a block. Put your hand down. To my job when she was in jail, and the alternator went out, and it was impounded. Now explain that to me. You drove her car, you had your own. For some reason, you drove hers. Why don't you give me a one sentence as to why you drove hers?
One sentence.
One sentence.
On my truck, I had my equipment, my lawn equipment, and I was just going 1 block away, so I didn't want to have to turn it around. And the car was impounded at my job, 1 block away from my house.
Why was it impounded?
Because it stopped on it. The alternator stopped.
Just a second. Cars aren't impounded because an alternator stopped.
The alternator stopped in the middle of the street. I couldn't move it. They had to tow it because it was in the driveway. They towed the car because the alternator stopped.
What you said, well, that's your fault, sir.
It's my fault her alternator went out?
Yes, sir. It's your fault that the car was impounded.
I'm listening. No, I'm really trying to understand.
I want you to listen. Yes, it's your fault. And I don't know what other nonsense there is here, but if Sarah was driving her car and it stopped running because the alternator went out, I'm going to take a guess and I'm going to say, Sarah, what would you do if your car stopped running in a driveway, blocking the driveway? What would you do?
Call AAA.
Call the tow truck and ask the tow truck to take it to a
Auto repair shop.
to an auto repair shop. Your first clue would not be just to leave the truck there and say, send it to impound.
No, it happened.
Just a second. Mr. Moore, please try not to test yourself on the dumb scale. Nobody who's responsible because a car breaks down leaves it in the middle of the road to be impounded. That doesn't make sense. It's illogical. Second thing I'm concerned about is when your car is impounded, in order to get it out of impound, which you say that you did, you have to show proof of title.
Yes.
Yes. Now, how did you get proof of title?
Because I had the title. I had the title.
Just a second. I hear the wheels. I hear you have the title because
I had access to her house.
Well, the title is in her name.
Right.
They wouldn't give you the car. You're not her. I mean, I would look at you and I say, not even close. Unless she gave you authorization in writing to get the car out for her, no impound service is going to let you take her car because anybody can pick up a title and say, I want that car out. Do you understand with me?
Here's my question. I end up getting a...
No, just a second.
Okay.
I want you to tell me where it was impounded.
It was impounded at my job. It was impounded and it was in a place that was a high traffic. I walked back to the house.
Yeah, I want to tell you something. You wouldn't know the truth if it came up and slapped you in the face, Mr. Moore.
That's what happened.
You wouldn't know the truth if it came up and slapped you in the face and introduced itself to you.
Okay.
Now, how much did it cost to get the car out of impound?
It cost me $1,000 total.
No, it didn't cost you anything because you took it out of her phone. Didn't cost you. It cost $1,000.
To get it insured, retitled, so I could have the ability to get the car out.
Well, how did you get her name on the title?
What you mean?
What do you mean, what do I mean? She has to sign it over to you in order to...
It was already signed over to me. It was already signed over. It was already signed. I sell cars, Ms. Judy.
You don't sell cars. You just told me that your car broke down on the way to your place of business.
Yeah, to my job.
On your job, and your job is not an auto mechanic or salesman for a car service, which is what you told me. I sell cars, Miss Judy. That's why the title was turned over to me, signed over, and I managed to get the car titled in my name. You want to try this on for me?
Judge Judy, I'm sorry, I didn't mean to disturb you, but I was every single day, and she would have lost her car. So
just say you.
Just a second.
No, I didn't.
Just a second.
I didn't forge anything.
Well, you had to have forged something, sir, because if it was in impound, and what you're saying is they were charging $30 a day, she was going to lose her car. Your next statement was, because you keep digging that hole a little deeper and a little deeper, you couldn't get it out because the car was in her name, not yours, but you had the title because you had access to the trailer, which is what she's suggesting, and you went and forged her signature, got a new title, got insurance, and the car was clearly towed, but you got it out of impound, that's what you said, with a new title in your name and insurance, also, I assume, in your name.
Yes, ma'am.
What did you do with the car?
Gave it back to her when she got out.
Just a second. You gave it back to her. Did you sign over the title?
Yes.
Shh. So you paid restitution.
Excuse me. Judge Judy. If you say something, I want to clarify.
Just a second.
Go ahead.
Did you
Just
sign
tell me
this?
when I can talk.
Did you sign this?
Yes, ma'am.
Then you're cooked.
Jill won more of stealing her money while she was in jail. John is countersuing, claiming Jill had him falsely arrested.
Now, did you sign over the title to her?
I signed over everything to her because she sold the car since then.
Oh, did you sell the car?
Sense all this?
Yes.
Yes, ma'am. But
I'm what?
He's what?
I had to go through police department and the sheriff's department and threaten him in order to get my title back. He would
Not at
not
all.
give me back my title.
Not at
Do
all
you have
the
any
truth.
proof of that?
Any proof of?
That you had to go through the police department, sheriff's department, or anything else in order to get your title back? Do you have any proof of that at all?
I don't have any proof of that, ma'am.
Okay. So it was $1,000 for impound that he took out of your account.
Correct.
That's $1,000.
No.
And
Okay.
did you take out $1,000 from her account to get it out of
No.
impound? Well,
I
you
paid
just said. Show me that you paid $1,000 to get it out of impound.
I can't show it to you because all the paperwork was in the car.
Did you pay impound by credit card or
I paid
cash?
it by cash.
Cash. Then you would have taken cash out
I had
from.
a job, Judge Judy. I made
You're
a
so
job.
full of baloney, sir.
I did have a job, Judge Judy.
You're so
How's that
full of baloney. Okay,
We were in a-
$1,000.
Okay.
Next, you say in your answer, Mr. Moore, that you paid for it. Your answer, you paid for it out of her
Judge
money.
Judy, that's kind of going back and forth.
Oh,
with tax.
listen.
We've split money back and forth. If I give you a copy of our Cash App, it's the exact same money back and forth over the last couple of years. I sent her money, she sent me.
Just a second.
So
Why would she do that, sir, if you have a girlfriend?
I'm
Why would you do
monogamously
that if you...
challenged.
Shh, listen. Why would you do that back and forth if what you said to me earlier was, I don't know what she's talking about. I live with my girlfriend in the same place as I'm living now. Now let's move on to, so far I have $1,000. And I really, Miss Wyatt, don't understand anything else. And I'm not spending any more time with your case. That's the person who should have been taking care of your business,
Yes.
not this nonsense.
Yes.
Not this nonsense, because I'm
I
not exactly
believe- I
sure
know
whether I'm
that.
getting the whole story from this side either. All right, now you have a counterclaim. Your counterclaim is for $2,000 for having you falsely arrested.
Yes, ma'am.
Let us move on with falsely arrested. After she gets out of jail, according to what I read, the two of you are kaput.
No.
Well, okay, here we go. We're going to go back to your answer and your counterclaim, sir. I'm going to read you what I said. On February 13th, I went out to a few bars to have a good time. Jill was at a different bar, but came and met me where I was at. Upon arrival, Jill started to pressure me to leave with her. I reminded her that we were no longer an item, and I didn't want to leave. She was making a scene, so we went outside to finish our conversation. That's your counterclaim. Now, pick it up from there. That's what you wrote. Try to
I wasn't
remember.
going anywhere.
Okay.
And then she told me, I'll show you. But you told me this thing, Judge Judy, if it's not accurate, would you want me to let you go ahead? Because I didn't write that. I signed it to them. They told me I'd be able to explain this to you as we're doing this here. I stopped and said, hell no, that didn't happen. No, we didn't fight. It wasn't one block. They said, you'll get a chance to explain that to the judge.
Yeah,
when you
well,
get
you
there."
shouldn't listen to anybody else. So when you sign a document that says, I Lash
we weren't
Moore,
an item.
being
We didn't
duly
live
sworn, deposes and says that this is accurate.
We didn't live together. We still knew
Would
each
you
other.
mind telling me what happened in the bar on February 13th?
She told me she was going to get me locked up for domestic violence because I had assaulted her. I had not assaulted her. I told her whatever, and I walked back into the bar, sat down, the police pulled up, and they said, sir, would you come step outside? Excuse me. They said, would you come step outside? I stepped outside. They said, put your hands behind your back. We're locking you up for domestic violence.
May I please have a copy of your complaint?
I can give you all this, what I have from...
Don't give me all that you have.
So you saying the complaint, I was arrested on the spot.
There was a disposition in that case.
Yes, they complaint to the disposition.
Oh, here we go. The case was dismissed in the interests of justice because you agreed to pay her restitution for just a second.
Yep.
That's what you agreed to pay her restitution in the amount of $246, which I assume represents the broken eyeglasses that she says that you broke. This says receipt of restitution monies. Same case. I, John Moore, state that I have delivered a check in the amount of $246 to the Calhoun County Prosecutor's Office. It is my understanding that this check represents the amount of restitution that is owed to the victim, according to the agreement entered into by the defendant. So you paid restitution.
Excuse me. Judge, I'm trying to, if you say something, I want to clarify.
Just a second.
Go ahead.
Did you
Just
sign
tell me
this?
when I can talk.
Did you sign this?
Yes, ma'am.
Then you're cooked.
So if
it's over.
I got a question for you.
No, I don't answer your questions.
If I get off of work, I've been to this court case 5 times in a row. It cost me $200 and some to come to court, and they said we'll dismiss all charges. There'll be no charges at all if you agree to pay $250. I've paid $800 here. I'll pay you the money, and then try to sue you for false arrest because I never harmed. Where's the glasses at?
Right, well,
where's the picture of the glasses? The police arrested me on the spot.
Mr. Moore, like a perennial victim, I really feel sorry for you. Your counterclaim's dismissed.
So if I'm
Just
getting
a sec,
arrested
Mr.
for
Moore,
doing anything, why wouldn't I pay
it's dismissed.
$250
Judgment
and
for
not
the
have to go to
plaintiff
court?
in the amount of $1,000. Your counterclaim's dismissed. I am finished with this case
Have a good-
permanently.
Thank you. Have a great day.
This court is adjourned.
It went just like I thought it would be.
I'm pleased with the results.
She mad I don't want to deal with her anymore.
My guards are up now.
Hey, she wanted to get her day in court. I can leave with it.
Not ask anybody for help.
She the one was locked up for. I've never been locked up for stealing. She was locked up for stealing. That's the thief. The pot calling the kettle black.
Just to be careful who you trust.
The sun filtered through the high windows of the courtroom, casting long and steady shadows across the polished wooden benches. It was a day of reckoning, but not the kind that usually fill the dark pages of a thriller. This was a story of 2 people who had known each other for 18 years, a span of time long enough for a child to grow into an adult, or for a friendship to weave itself into a complicated tapestry of shared memories and missed opportunities. The air was filled with a quiet murmur of anticipation as the bailiff called for order. Case number 3046 was officially on the bench, separated by more than just physical distance. They were separated by their own conflicting versions of a shared past. Judge Judy took her seat with the practiced grace of someone who had seen every facet of human nature. She looked at the 2 individuals before her, searching for the truth beneath the layers of frustration and legal jargon. The story began with a simple question of duration. Jill Wyatt explained that their history stretched back nearly 2 decades. They had shared lives and homes on and off, with the most recent domestic arrangement occurring in January of the year 2022. It was a house. Jill recalled a place where the foundation was built on informal agreement rather than a stack of legal papers. But as the questioning continued, the narrative began to shift. Mr. Moore, standing with a look of practiced indifference, offered a starkly different account. He claimed they had never shared a relationship, never lived together in the way Jill described. To him, the house was a place where he lived with his current girlfriend, a reality that Jill was only a peripheral part of. The tension in the room rose as the judge dug deeper into the nature of their living situation. Mr. Moore spoke of a time when Jill was supposed to move into an apartment, but decided against it after a disagreement with a neighbor. The judge, would her kids simply know about the temperaments of upstairs neighbors unless one is physically present in the space? The truth, like a slow rising tide, began to emerge. They had indeed spent time together under that roof. As the narrative unfolded, the focus shifted to a period of difficulty in Jill's life. In the year 2018, she had made a mistake that resulted in a conviction. By the year 2022, a violation of her probation led to a period of incarceration lasting 78 days. The crime itself was small in the eyes of the law, a matter of $170 involving the theft of a Thanksgiving dinner. It was a moment of desperation, perhaps, or a lapse in judgment that carried a heavy price. While she was away, she entrusted her life and her finances to the person she thought she knew best. She gave Mr. Moore her phone, the digital key to her bank account, and her communication with the outside world. Mr. Moore accepted the phone, but his understanding of the responsibility was clouded. He spoke of keeping up with her affairs, paying bills, and contributing to her commissary fund. But as the judge probed further, the details became murky. There was a trailer involved, a place where Jill lived before she went to jail. She had hoped Mr. Moore would look after it, perhaps even stay there to keep abreast in complexities of his own life, including a girlfriend who was less than pleased with the arrangement. The courtroom then turned its attention to a series of financial transactions. Money had moved back and forth through a digital application called Cash App. Jill alleged that Mr. Moore had taken thousands of dollars from her account, money that was meant for her survival and the maintenance of her life. Mr. Moore countered that the money was used for her benefit or was part of a mutual exchange they had practiced for years. One of the most contentious points involved a car. During the time Jill was incarcerated, Mr. Moore had taken upon himself to drive her vehicle. He claimed it was a short trip, a mere one-block journey to his place of work, because his own truck was loaded with heavy equipment. But during that one-block drive, the alternator failed, leaving the car stranded in the middle of a busy street. The vehicle was subsequently impounded. To get out, Mr. Moore had to navigate the bureaucratic maze of titles and insurance. He managed to retitle the car in his own name, an act that Jill viewed with deep suspicion. He claimed he did it to save the vehicle from being lost to the impound lot, where fees were mounting at a rate of $30 every single day. He spent $1,000 of her money to resolve the situation, eventually signing the title back to her once she was released. Masterclass in the analysis of accountability. The judge pointed out that a responsible person does not leave a broken car in the middle of a road to be towed. They call for assistance. They find a way to move it to a safe location. The logic of Mr. Moore's actions seemed to fray at the edges, much like the relationship he had with Jill. The case then moved toward the counterclaim. Mr. Moore sought $2,000 for what he termed a false arrest. He recounted an evening in February when they both found themselves at the same establishment. He claimed that Jill had pressured him to leave with her, and when he refused, she made a scene. He alleged that he was later arrested for domestic violence based on a false report that he had assaulted her. He spoke of the frustration of being locked up and the financial burden of attending court 5 times to clear his name. The evidence, however, told a more nuanced story. A document from the prosecutor's office revealed that the case was dismissed in the interest of justice because Mr. Moore had agreed to pay restitution. He had delivered a check for $246 to cover the cost of a pair of broken eyeglasses. The judge noted that an agreement to pay restitution is often seen as an admission of some level of responsibility. The counterclaim for false arrest began to crumble under the weight of this legal reality. Looked at the 2 individuals standing before her. She saw a woman who had tried to maintain her life from behind bars, and a man who had struggled with the weight of commitment he was perhaps unequipped to handle. She saw the son of Jill, a grown man named Andrew Porter, who stood quietly in the courtroom, a silent witness to the chaos. The judge wondered aloud why Jill had not entrusted her affairs to her own family, a question that pointed to the complicated trust Jill still held for Mr. Moore despite their history. In her final analysis, the judge dismissed the counterclaim for false arrest. She found that the money taken for the car impound and other unexplained expenses justified a judgment in favor of Jill. The amount was set at $1,000. It was a resolution that aimed to balance the scales of justice, acknowledging the financial loss without descending into the bitterness that had characterized much of the testimony. Outside the courtroom, the air felt lighter. Mr. Moore walked away, still maintaining his own perspective on the situation, while Jill prepared to move forward with her life. There was a lingering sense of irony in the situation, encapsulated by a phrase that had been whispered in the halls. Mr. Moore had described himself as being monogamously challenged, a line that brought a touch of humor to an otherwise heavy day. It was a reminder that human relationships are rarely simple and that the of our daily lives. The story of Case 3046 was more than dispute over money. It was a lesson in the importance of clear communication, the value of family, and the necessity of taking responsibility for one's actions. It showed that even in the face of conflict, there is an opportunity for growth and a chance to find a positive path forward. As the court adjourned, the participants left with a clearer understanding of the boundaries that define our connections to one another. The world continued to turn, and for Jill and John, the long chapter of their shared 18 years had finally reached a definitive conclusion, allowing them both to seek a future built on a more stable foundation of honesty and self-awareness. The halls of justice often echoed the heavy footsteps of those seeking closure, but inside courtroom 3046, the atmosphere felt unusually personal. Mr. John Moore stood on one side, a man whose charm seemed to have been honed over years of navigating complicated social waters. Opposite him was Miss Jill Wyatt, a woman whose face told a story of 18 years of history with the man across the aisle. This was not just a case about money or a car. It was a narrative about trust, the complexities of human relationships, and the long road to personal responsibility. The Honorable Judge Judy took her seat. She looked over the documents before her, her sharp eyes scanning the details of Case 3046, Wyatt versus Moore. The bailiff called the court to order, and as everyone took their seats, the air grew thick with the anticipation of the story about to be unraveled. The judge began by asking Miss Wyatt about the nature of her relationship with Mr. Moore. They had known each other for nearly 2 decades, a lifetime of shared memories and intermittent periods of living together. The last time they shared a home was in January of 2022. It was a house, though the legal arrangements were murky, involving informal agreements and cash payments that left no paper trail. Mr. Moore, however, offered a different version of the story. He denied ever having a formal relationship or living with Miss Wyatt in the way she described. He spoke of having a girlfriend throughout the entire period, claiming that his visits to Miss Wyatt were nothing more than brief encounters. But the judge was seasoned in the art of detecting hesitation. She noticed Miss Wyatt seemed reluctant to share certain details, while Mr. Moore appeared to be playing a game of semantics. When pressed about a specific house in January of 2022, Mr. Moore initially denied any knowledge of it. However, under the relentless questioning of the judge, the truth began to seep through the cracks of his defense, though he insisted it was only after she failed to get along with a neighbor upstairs. It was a small victory for the truth, proving that they had indeed shared a space and a life, if only for a short time. The narrative then shifted to a trailer that Miss Wyatt had been renting. This trailer became the center of the dispute when Miss Wyatt was incarcerated for 78 days. The reason for her time in jail was a poignant detail in this long saga. In 2018, she had been convicted of retail fraud for stealing a Thanksgiving dinner. It was a crime born of a moment of need, a reflection of the struggles people face when trying to provide for themselves and their loved ones. She had been placed on probation, but a failure to maintain contact with her probation officer led to her 78-day sentence in 2022. Before she went to jail, Miss Wyatt had entrusted Mr. Moore with her phone and her bank account. The agreement was simple in her mind. He was to take care of her bills, pay the rent on the trailer, and ensure she had money for the commissary. Mr. Moore acknowledged receiving the phone, but his interpretation of the task was far more fluid. He claimed the money was used for various items, including a phone bill and computer, though the details remained hazy. He even suggested that Miss Wyatt wanted him to stay in her trailer while she was gone, living with another girlfriend. In the middle of this domestic tangle stood Andrew Porter, Miss Wyatt's adult son. He was a field engineer, a man of steady work and clear speech. The judge looked at him and asked why his mother had not entrusted him with her affairs instead of Mr. Moore. It was a question that hung in the air, highlighting the sometimes irrational choices people make when they are in the midst of emotional turmoil. Andrew stood by his mother, a silent testament to the fact that there were stable people in her life, even if she had chosen a more complicated path during her crisis. The core of the legal battle focused on the funds in Miss Wyatt's account. She alleged that Mr. Moore had withdrawn thousands of dollars, only a fraction of which reached her in jail. When she was released, the account was nearly empty. Mr. Moore claimed that there had been $600 left in the account when he returned the phone, but he had no documentation to prove it. He spoke of Cash App transactions that flowed back and forth over the years, a digital record of a relationship built on shifting financial sands. Then came the saga of the car. While Miss Wyatt was in jail, Mr. Moore had driven her vehicle. He claimed he only drove it a block to his place of work because his own truck was loaded with heavy equipment. During that short trip, the alternator failed, and the car was eventually a responsible person would leave a car in the middle of a driveway to be towed instead of calling for a repair service. Mr. Moore's explanation became even more convoluted when he discussed how he retrieved the car from the impound lot. He claimed it cost $1,000 to get out and that he had managed to get the car retitled in his own name. This revelation was the turning point in the case. To retitle a car, one needs a signature of the owner. Mr. Moore claimed the title had already been signed over to him because he sold cars, but the judge saw through the fabrication. It became clear that he had taken advantage of his access to Miss Wyatt's home to gain control of her vehicle. The judge's frustration grew as Mr. Moore continued to offer illogical explanations. He claimed he had eventually signed the car back over to Miss Wyatt, but the damage was already done. He had used her funds to pay for the impound fees and the retitling, essentially using her own money to solve a problem he had caused. The judge noted that if a car breaks down, a responsible person calls a tow truck and takes it to a mechanic. They do not let it get impounded and then forge documents to change the ownership. As the afternoon wore on, the court addressed Mr. Moore's counterclaim. He was suing Miss Wyatt for $2,000, alleging false arrest. He described an evening in February, according to his written statement. Miss Wyatt had made a scene, demanding that he leave with her. He claimed that she later falsely accused him of domestic violence, leading to his arrest. However, when the judge read his own statement back to him, Mr. Moore tried to distance himself from the words, claiming he had not written them himself. The truth of the encounter at the bar was revealed through the legal documents of the case. The charges against Mr. Moore had been dismissed, but only because he had agreed to pay restitution to Miss Wyatt for her broken eyeglasses. He had signed a document admitting that he delivered a check for $246 to the prosecutor's office as part of settlement. The judge looked at him and told him that since he had signed the agreement and paid the restitution, he was essentially admitting fault in the eyes of the law. His claim for false arrest was groundless because the legal process had reached a conclusion based on his own agreement to pay for the damages he caused. Mr. Moore attempted one last time to cast himself as the victim, complaining about the cost of his multiple court appearances. But the judge was unmoved. She dismissed his counterclaim with a sense of finality. She ruled in favor of Miss Wyatt for the sum of $1,000, representing the money Mr. Moore had improperly taken from her account to deal with the impounded car. As the session ended and the parties prepared to leave the proceedings, Mr. Moore had made a comment that almost went unnoticed in his long, rambling explanations. He had described himself as being monogamously challenged. It was a moment of unintended honesty that seemed to summarize the entire history of his relationship with Miss Wyatt. He was a man who lived between stories, between relationships, and between truths. Miss Wyatt left the courtroom with a sense of relief. She had sought justice for the breach of trust she had experienced, and the court had validated her claim. The journey from a 78-day jail sentence for a 5-year-old mistake to a $1,000 judgment was a long and difficult one. It was a story about learning to trust the right people, such as her son Andrew, and moving away from those who thrive on chaos and deception. The case of Wyatt versus Moore served as a reminder that the law is not just about numbers and statutes. It is about the human experience, the mistakes we make, and the steps we take to rectify them. It was a story of a Thanksgiving dinner stolen in desperation, a car left on a street corner, and the slow, deliberate process of finding the truth in a sea of contradictions. As the lights in courtroom 3046 were turned off, the echoes of the trial remained, a narrative of resilience, the pursuit of fairness, and the enduring hope for a more honest future, maintaining his air of a man misunderstood by the world. But the record was clear. The judge had seen to the charm and confusion, delivering a verdict that focused on the facts. Miss Wyatt, now free from the legal and emotional ties to Mr. Moore, could look forward to a new chapter in her life, supported by her family and the knowledge that she had stood up for herself. The small, humorous, and deeply human moments of the trial, from the description of the alternator failure to the monogamously challenged confession, would be remembered as part of the tapestry of their long history. In the end, the values of education and humanity prevailed, proving that even in the most tangled of relationships, the truth has a way of introducing itself, sometimes with a slap in the face and a clear introduction. The morning sun filtered through the tall windows of the courtroom, casting long and steady shadows across the polished wooden benches. It was a place where stories often met their final chapters, and today, the story of Jill Wyatt and John Moore was about to be laid bare before the world. This was not a tale of grand conspiracies or dark mysteries, but rather a human drama about trust, the complexities of long-term relationships, and the search for clarity in the aftermath of a personal storm. Inside the Hall of Justice, the atmosphere was thick with a quiet hum of anticipation. At the center of it, seeking the truth, was as sharp as the gavel she held. The case before her, numbered 3046, seemed simple on the surface, but like any story involving two people who had known each other for 18 years, it was layered with history and unspoken emotions. Jill Wyatt stood at her podium, her face etched with a mixture of weariness and hope. She was suing her former partner, John Moore, for the money that had vanished from her life while she was serving a sentence of 78 days in jail. It was a difficult period of her life, one born from a mistake involving the theft of a Thanksgiving dinner. While 78 days might have seemed like a significant amount of time for a crime worth only $170, it was a violation of her probation that ultimately led her to the cold reality of a cell. John Moore stood across from her, appearing confident yet somewhat restless. He was a man who worked as a field engineer, traveling across state lines and managing complex equipment. To him, the past few years were a blur of shared finances and mutual support, or so he claimed. He had filed a counterclaim for $2,000, alleging that Jill had caused him to be falsely arrested after she was released. The proceedings began with a call to order. Everyone rose as a judge entered, the weight of the law settling into the room. As they took their seat commenced, Jill explained that their bond had spanned nearly 2 decades, characterized by periods of living together and shared experiences. However, when the judge asked about the nature of their last shared residence in January of 2022, the narrative began to splinter. Jill recalled a house, an arrangement made without formal paperwork, but rooted in their connection. John, however, offered a different version of reality. He claimed they had never truly lived together in the way a committed couple might. He spoke of having a girlfriend during that entire period, a revelation that added a layer of complexity to their already tangled history. He described his visits to her as occasional, yet he could not deny his presence in the house she described. When pressed by the judge about the house Jill mentioned, John initially hesitated. He tried to distance himself from the memory, but the truth had a way of surfacing. The judge, with her keen eye for detail, noted that one does not simply know about the lady upstairs or the internal dynamics of home unless they have spent significant time within its walls. The story shifted to a trailer, a more modest dwelling where Jill had lived before her incarceration. It was during her 78 days away that she had entrusted John with her most personal belongings, including her phone and her bank account access. Trailer secure and ensure her life did not fall apart while she was gone. John acknowledged receiving the phone, but his interpretation of his duties was far narrower. He claimed he was only meant to provide her with commissary funds and keep track of her things, a vague phrase that soon became the heart of the dispute. As the testimony continued, the judge's focus turned toward Jill's son, Andrew Porter. He stood tall and silent beside his mother, a picture of stability in a sea of chaos. The judge wondered aloud why Jill had not entrusted her affairs to her own son, a capable and working man, rather than to John. It was a moment of reflection for everyone in the room. Often, in the midst of life's challenges, we reach for the familiar, even if the familiar is not the most reliable path. The tension in the courtroom rose as the discussion turned to Jill's car. While she was away, John had used a vehicle, claiming he only needed to drive a short distance for his work. However, the car's alternator had failed, leaving it stranded and eventually impounded. John's explanation for the impoundment was a source of frustration for the court. A responsible person, the judge noted, would have called for a tow truck or sought a repair shop rather than leaving the vehicle to be seized by the authorities. The mystery deepened when it was revealed his own name. He claimed he did this to save the vehicle from being lost to the impound lot, which charged $30 every single day. He insisted he had used his own money, yet also admitted that the funds came from their shared and often confusing back-and-forth transactions on a mobile payment application. The judge pressed him on how he could have legally transferred the title without Jill's signature. John's claims of being a car salesman and having the title signed over to him were met with deep skepticism. The narrative took a sharper turn as the judge examined the counterclaim regarding the false arrest. John described a night in February of 2026 when both he and Jill were at different bars. He claimed she had pressured him to leave with her, and when he refused, a scene had unfolded. He alleged that he was arrested for domestic violence despite his innocence. However, the court records told a more complete story. The charges had been dismissed only after John agreed to pay restitution of $246 for Jill's broken eyeglasses. By signing that agreement and paying the money, he had essentially acknowledged his role in the incident. In the end, the judge's wisdom cut through the confusion. She recognized that the financial relationship between Jill and John was a messy tapestry of shared costs and poor decisions. Impoundment, a clear consequence of John's actions while Jill was unable to protect her own interests. The gavel fell, bringing an end to the legal battle. The counterclaim was dismissed, and a judgment was rendered. As Jill and John left the courtroom, the air seemed lighter, though the weight of their 18-year history still lingered. Jill felt a sense of relief, a realization that she could indeed stand on her own 2 feet without asking for help from those who were not fully committed to her well-being. She looked at her son, Andrew, and saw a future built on genuine trust. John, meanwhile, remained a man of many words, attempting to explain away the complexities of his life. He famously described himself as being monogamously challenged, a phrase that brought a rare, quiet chuckle to those who heard it. It was a candid admission of his own nature, one that perhaps explained the many contradictions in his testimony. The lesson of the day was clear and resonant. Truth is not something that can be easily hidden or manipulated. It is a steady force that, when introduced, has the power to clear the fog of misunderstanding. For Jill Wyatt, it was a day of reclaiming her narrative and moving forward with a renewed sense of purpose. For the observers in the court, it was a reminder that even in the most complicated lives, there's always a path toward justice. Emptied and the lights were dimmed. The echoes of their voices faded into the history of the building. The story of the stolen Thanksgiving dinner, the broken alternator, and the 18 years of friendship and friction was finally settled. It was a story of human imperfection, but more importantly, it was a story of the resilience of the human spirit and the enduring power of the truth. Justice had been served, not with a heavy hand of tragedy, but with a firm and fair resolution that allowed everyone to walk away with a little more clarity. The path ahead for Jill was one of independence, supported by the quiet strength of her family. The path for John was his own to navigate, perhaps with a better understanding of the responsibilities that come with trust. And so, the sun continued its journey across the sky, shining down on a world where every ending is simply the beginning of a new and wiser chapter. In the quiet moments following the trial, Jill sat with Andrew in a small cafe nearby. They did not talk much about the money or the car. Instead, they spoke of the future, of simple goals and the importance of integrity. The humor that had occasionally flickered in the courtroom now felt more natural, a gentle light guiding them home. They shared a meal, one that was earned and appreciated, a symbolic contrast to the meal that had started Jill's legal troubles years before. There was a newfound peace. They had witnessed the law in action, not as a cold machine, but as a human institution designed to bring order to life's chaos. It was an educational experience, a reminder that every action has a consequence, and every story has multiple sides. By facing the truth, they had found a way to turn a difficult chapter into a source of inspiration. As they walked toward their car, the one Jill had worked so hard to get back, she felt a sense of pride. It was more than just a vehicle. It was a symbol of her resilience. She had faced her past, answered for her mistakes, and stood up for herself when it mattered most. The journey was long and the road was often bumpy, but she was finally behind the wheel of her own life, driving toward a horizon filled with positive emotions and endless possibilities. The legacy of the day was not the judgment or the restitution, but the restoration of dignity. It was a realization that no matter how many times a person might stumble, there's always an opportunity to stand up, brush off the dust, and walk with their head held high. This was the true essence of the day's events, a story worth telling and a lesson worth remembering for anyone who has ever felt lost in complexities of the heart and the law.